Welcome to EUPrivacyForAll Session 46 on GDPR, Article 57, Tasks of the Supervisory Authority. Article 57 on the Tasks of Supervisory Authority lays down that without prejudice to other tasks set out under the GDPR, each supervisory authority shall on its own territory monitor and enforce the application of the regulation, promote public awareness and understanding of the risks, rules, safeguards and rights, specifically regarding children's rights, advise the national parliament, the government and other institutions and bodies, promote the awareness of controllers and processors of their obligations, and upon request provide information to any data subject concerning the exercise of their rights, handle complaints and investigate and inform data subjects regarding those complaints, in particular if further investigation or coordination with another supervisory authority is necessary. Cooperate with, including sharing information and providing mutual assistance to, other supervisory authorities, conduct investigations, monitor relevant developments, adopt standard contractual clauses nationally, establish and maintain a list in relation to the requirement for data protection impact assessment, give advice to controllers and processors, encourage the drawing up of codes of conduct, and provide an opinion and approve such codes of conduct, encourage the establishment of data protection certification mechanisms, seals and marks, and where applicable, carry out a periodic review of certifications. Additionally, draft and publish the criteria for accreditation of a body and conduct the accreditation of such body. Authorize contractual clauses, such as ad hoc clauses, approve binding corporate rules, contribute to the activities of the European Data Protection Board, keep internal records of infringements, fulfill any of the tasks related to the protection of personal data. Each supervisory authority shall facilitate the submission of complaints by measures such as a complaint submission form. The performance of the tasks of each supervisory authority has to be free of charge for the data subject and, where applicable, for the data protection officer. Finally, where requests are manifestly unfounded or excessive, the authority may charge a reasonable fee. The supervisory authority will have to bear the burden of demonstrating the manifestly unfounded or excessive character of the request. A key recital in the GDPR is Recital 129. It sets forth that the supervisory authorities should have in each member state the same tasks and effective powers, notably regarding investigation, corrective powers and sanctions, and authorization and advisory powers, in particular regarding complaints from natural persons. Such powers should include the power to impose a temporary or definitive limitation, including a ban on processing. It also stresses that the measures taken by the supervisory authority concerned should be appropriate, necessary, and proportionate. That is to say, taking into account the right of every person to be heard before any individual measure would be taken and affect him or her, in order to avoid superfluous costs and excessive inconveniences for the persons concerned, meaning data subjects, of course, but also controllers and processors. Each legally binding measure should be in writing, be clear and unambiguous, and it may give rise to judicial review. Currently, Article 28 of the Directive lays down that each member state shall provide that the supervisory authorities are consulted when drawing up administrative measures or regulations, and that, among other tasks, each supervisory authority shall hear claims and the person concerned will be informed of the outcome of the claim. Drawing up a report on the supervisory activities at regular intervals is also part of the tasks of the DPAs. What should accountable data controllers and processors get prepared for? First, they will have to be aware of their obligations under the General Data Protection Regulation and understand the risks, rules, safeguards, and rights in relation to the processing of personal data as promoted by each supervisory authority, specifically when addressed to children. They will also have to be aware that cooperation between supervisory authority means sharing information and providing mutual assistance with a view of ensuring consistency in application and enforcement of the GDPR. Each supervisory authority will maintain a list on requirements for data protection impact assessments that might be useful. Controllers and processors will also have to use new compliance tools such as codes of conduct, certification, or national standard contractual clauses as provided by DPAs. Each supervisory authority will facilitate the submission of complaints using submission forms which can be completed also electronically. And this is something that will be key regarding the investigative powers of supervisory authorities. Controllers and processors shall finally bear in mind that each measure from a data protection authority should be appropriate, necessary, and proportionate, respecting the right of every person to be heard before any individual measure which would affect him or her adversely is taken, and avoid superfluous costs and excessive inconvenience. That is to say that each legally binding measure from a data protection authority should be in writing, clear and unambiguous. Key question now will be to know more about the consistent implementation of the different tasks identified by the GDPR by each national data protection authority.